Hello, I'm Michael Swainston, a barrister from Brick Court Chambers in London, and I'm honoured to be asked to speak at this online session of the St. Petersburg International Legal Forum. The real forum is a casualty of the coronavirus, but I'm sure its recovery will be swift, and I look forward, along with you, I'm sure, to a full forum in St. Petersburg in 2021. I've been asked to speak about the legal implications of coronavirus, COVID-19. And there are many of those, so it's difficult to know where to start. It seemed to me, therefore, sensible to start with the biggest issue that, in my view, requires legal attention. And that is the way in which unilateral sanctions are affecting the ability of some states to fight this terrible scourge. Does the law have anything to say about that? In my view, it does. One aspect is obviously human rights, but I'm going to put that to one side for a moment and talk about the General Agreement on Tariffs and Trade, GATT. Under GATT, very many nations committed themselves to reducing barriers to trade in order to promote international economic development. The agreement came into force on the 1st of January 1948, which was soon enough after the Second World War for the world to know that protectionism and isolationism breed conflict. Early signatories included Belgium, the Netherlands, the United Kingdom, and the United States. And since then, much of the world has signed up. 128 states, including, for example, the Russian Federation, Venezuela, and Cuba. Iran has observer status. The preamble of the agreement records the objectives of the states that support it. They recognize that their relations in the field of trade and economic endeavor should be conducted with a view to raising standards of living and developing the full use of the resources of the world. And these countries also state that they are desirous of contributing to these objectives by entering into reciprocal and mutually advantageous arrangements directed to the substantial reduction of tariffs and other barriers to trade, and to the elimination of discriminatory treatment in international commerce. In order to achieve all of that, the main provisions of the General Agreement do a number of things. They prohibit discriminatory tariffs, they guarantee freedom of transit of goods, and they forbid discrimination in commerce. Importantly, nothing in this scheme allows the use of unilateral sanctions against another state. That, for some, is controversial, and those who like sanctions generally try to justify them by reference to Article 20 of GATT, so we should look at that. Article 20 contains limited exceptions to the rules in the treaty. The first, subparagraph A, says that a contracting party need not provide information where disclosure would be contrary to its national security interests. So it's irrelevant, in other words, to sanctions. Then subparagraph B says that nothing in the agreement shall be construed to prevent any state from taking any action which it considers necessary for the protection of its essential security interests. Those who support sanctions usually cite this provision. However, the provision doesn't stop there. The protective measures must relate to one of three things: fissionable materials, traffic in arms and ammunition, or thirdly, states can take special measures in time of war or other emergency in international relations. So you can restrict trade in fissionable materials, you can restrict trade in weapons, and you can restrict trade in time of war or other emergency in international relations. None of these seem to justify sanctions in peacetime that erect barriers to trade around a particular country. Nothing here says anything about adopting unilateral measures aimed at suppressing a target country's economy and driving down its living standards. On the contrary, remember the objectives of GATT: to raise standards of living generally and to eliminate discrimination in international commerce. But what about those who say that the essential security interests of a particular state can allow it to take unilateral steps to promote, for example, international peace and security? Well, the treaty says nothing about states imposing their unilateral view, but it does cover the issue of international peace and security. The third and final exception under Article 20 of GATT says this: nothing in the agreement shall be construed to prevent any contracting party from taking any action in pursuance of its obligations under the United Nations Charter for the maintenance of international peace and security. So in other words, a state could depart from the rules in GATT in order to comply with directives of the UN Security Council or to comply with United Nations sanctions. But the implication is that international peace and security is the exclusive province of the United Nations. Unilateral sanctions cannot be justified, at least without UN approval. For me, the illegality of many unilateral sanctions under GATT seems pretty clear. If we had time, it would also be cleared by human rights standards around most of the world. I anticipate, too, that it would be clear for any objective tribunal. Unfortunately, there are problems with resolving matters through objective tribunals, which in the context of GATT means the dispute resolution bodies of the World Trade Organization. First, even when it works, the WTO process takes a long time, at least a year or so, and in present circumstances, that's a rather long time to wait. Then, on important points of law, there's likely to be an appeal to establish an authoritative answer, which takes more time. However, there's an even more fundamental problem. This process does not presently work. The WTO appellate body should have 7 members. On the 11th of December 2019, it fell below its quorum of 3 members so that it can no longer function. The result is, appeals cannot be heard, and decisions of WTO panels cannot be adopted by the dispute settlement body in accordance with the WTO's rules and procedures. In other words, the rules-based approach to international commerce has broken down. Why has this happened? The reason is that in recent years the United States has blocked the appointment of replacement members to the appellate body. Of course, the United States is one of the countries that likes to impose unilateral sanctions. This move suggests that it's less enthusiastic about debating the legality of them. Now, problems like this are rarely debated in national parliaments, and the general public is not usually aware of them. Perhaps coronavirus will have one benefit of focusing minds and allowing people time to think. I would suggest that people could usefully ask themselves an important question. Is it right for individual countries to apply sanctions against other states that have the effect of restricting access to critical medical care? We have all seen enough very disturbing pictures in the news to understand exactly what that means. If you have a point of view, and now that you have spare time to express it, perhaps you could write to your Member of Parliament, or even to your President. And as lawyers, you can perhaps write better letters than most. Yesterday, the General Assembly of the United Nations passed a resolution calling for international cooperation and multilateralism in the fight against COVID-19. That echoes the objectives of GATT. The resolution stresses the need for full respect for human rights, and it also says that there is no place for any form of discrimination, racism, and xenophobia in the response to the pandemic. This too echoes the prohibition on discrimination in GATT. These are important words, and as lawyers we know that words can be very important. But let's hope that on this occasion they're not just words.